Welcome to the deep dive. Today we're looking into a brand new piece of legislation that's just hit the floor in Canada's House of Commons.
That's right. We're focusing strictly on excerpts from a new federal bill, Bill C-5. It just had its first reading on June 6th, 2025.
Okay, and the full title is, let me get this right, an Act to Enact the Free Trade and Labor Mobility in Canada Act and the Building Canada Act. That's quite a mouthful.
It is, yeah. But the proposed short title is much simpler. The One Canadian Economy Act makes it a bit clearer what they're aiming for, perhaps.
Right. So our mission for this deep dive is to unpack what's actually in this bill, according to the text itself.
Exactly. We're looking at the key proposals, what it seems designed to change or achieve, based purely on the summary and the provisions in these excerpts you've got.
And it jumps out straight away that it's structured in two distinct parts. It's not just one single focus.
No, it sets up two separate acts, actually. We should probably tackle them one by one.
Makes sense. Let's start with part one then. It establishes the Free Trade and Labor Mobility in Canada Act. What's the gist of this part based on the preamble and purpose sections?
Well, the stated goal here is pretty clear. Promoting free trade and labor mobility within Canada, internal movement.
So tackling those persistent barriers between provinces and territories for goods, services, maybe even people trying to work across borders.
That seems to be the target, yeah. The text specifically mentions removing federal barriers to interprovincial trade and improving labor mobility. The focus is on the federal side of things.
And there's a goal mentioned about making it easier for Canadians, for businesses, to buy Canadian products and services.
Yes, facilitating that internal market. But the text also makes a point of saying this is intended while still maintaining protections for health, safety, security, well-being, the environment. The usual important caveats.
Okay, so how does the bill propose to actually do that? I saw something about mutual recognition.
Right. The preamble talks about working towards a system where, if something meets the requirements in one place, province, territory, or federally, it's recognized everywhere. Part one of this bill deals with the federal piece of that puzzle.
Got it. So let's look at the mechanics. Section 8 is about goods. How does the text say it works for, say, a product made in one province?
Okay, Section 8 proposes that, subject to regulations, if a good meets a provincial or territorial requirement for its production, use, or distribution, then it's considered to meet any comparable federal requirement.
Considered to meet. So it's like a presumption. If you meet the provincial rule, you're kind of assumed to meet the federal one if they're comparable.
That seems to be the core idea, yes. Then Section 8.2 defines comparable. It means the requirements cover the same aspect or element, aim for a similar objective, and meet any conditions laid out in the regulations.
And who decides if they are comparable?
That falls to a federal regulatory body according to Section 8.3. They make the determination.
Okay. Is it a similar setup for services in Section 9?
Very similar, yes. Section 9.1 says, again subject to regulations, a service provided under a provincial or territorial requirement is considered to meet a comparable federal one.
Is there a catch?
There's a condition mentioned. The provincial or territorial requirement has to, continue to apply to the person providing the service. They have to stay compliant back home, so to speak.
Right, makes sense. And comparable means the same thing as for goods.
Yes, Section 9.2 uses the same definition, same aspect, similar objective, meets regulatory conditions. And again, Section 9.3 says a federal regulatory body decides if they're comparable.
Then Section 10 shifts to labor mobility. How's that handled? It seems maybe a bit different.
It does read a bit more directly. Here, subject to regulations, it says, a federal regulatory body must recognize an authorization think license, certification from a provincial or territorial body as comparable to their own.
Must recognize.
Yes. And crucially, they must then issue the federal authorization to the person holding the provincial or territorial one, if they apply.
That must feel stronger than considered to meet. What's the difference in effect, do you think, based on the text?
Well, the wording suggests perhaps a more automatic pathway for workers, right? If you have the provincial license, the federal body has to recognize it and issue theirs, unless regulations say otherwise. For goods and services, it's more about the requirements being deemed met federally. It's a subtle but maybe important distinction.
And regulations play a big role throughout this. Section 11 talks about the power to make them.
A very significant role. Section 11 gives the governor and council, that's the federal cabinet, broad power to make regulations about these federal barriers. And notably, Section 11(1)(a) allows them to create exceptions to these rules for goods, services, and labor mobility we just discussed.
Exceptions. So they could carve things out.
Potentially, yes. The regulations can also impose obligations, prohibitions, conditions, restrictions. It's quite broad.
Is there any check on creating those exceptions?
There's a consultation requirement. Section 11.2 says before recommending an exception, the minister has to consult the relevant federal regulatory body.
Okay. Moving on, Section 12 mentions liability limits. What's that about?
Section 12.1 basically gives immunity from civil lawsuits to the Crown, federal bodies, their staff, for actions taken in good faith when applying these rules in Sections 8, 9, or 10.
So if officials are trying to follow these new rules properly, they're protected from being sued over it.
That's the general shield, yes.
Yeah.
But Section 12.2 adds a really important clarification. This immunity does not cover judicial review, challenging the legality of a decision in court or procedures under Chapter 10 of the Canadian Free Trade Agreement. So certain legal challenges are specifically allowed.
Interesting carve-out. And finally, for Part 1, there's a review clause.
Yes, Section 13. It requires the minister to review how this act is working within 5 years after it comes into force and report back to Parliament. Standard practice for major legislation often.
And the whole thing, this Free Trade and Labor Mobility Act, only starts when the government decides, right? Section 3 of the main bill says it comes into force on a day fixed by the governor and council.
Correct. So that naps up the internal trade and labor side.
Okay, let's shift gears then. Part 2 enacts the Building Canada Act. This sounds quite different.
Completely different focus, yes. The preamble and purpose sections here talk about advancing national interest projects.
National interest projects. And the goal, according to Section 4.
It's explicitly about boosting Canada's prosperity, national security, economic security, defense, and national autonomy. Big picture stuff.
And the method is an accelerated process for these projects.
That's the language used, yes. An accelerated process to enhance regulatory certainty and investor confidence. But again, the text adds the qualifier, while still protecting the environment and respecting Indigenous rights. That balance is stated again.
Okay, crucial question then. What is a national interest project according to this bill? Section 2 defines it.
Very simply, Section 2 says it's a project named in Schedule 1 of this Act. That's it. The list is key.
And authorization means the federal permits needed for these projects.
Correct. Any approval, permit, license, whatever federal document is needed under the laws listed in Schedule 2 to actually carry out the project.
So, who gets to put projects on that Schedule 1 list?
That power, Section 5 gives it to the governor and council. They can add a project if they decide it's in the national interest.
And what helps them decide that? Does the bill give any criteria?
It does. Section 5.6 lists factors they may consider. Things like strengthening Canadian autonomy or security, economic benefits, likelihood of success, advancing Indigenous interests, and contributing to clean growth or climate goals. Echoes the Act's purpose.
Is that power to add projects permanent?
No, there's a sunset clause. Section 5.2 says the power to add new projects expires 5 years after the section starts. They can still amend or delete projects later, though, according to Sections 5.3 and 4. Although Section 5.5 says they can't delete a project once the main document we'll discuss has been issued for it.
What about consultation before adding or changing the list?
Yes. Section 5.7 mandates consultation before recommending an addition, amendment, or deletion. They have to consult other federal ministers, provinces, or territories, and, importantly, Indigenous peoples whose Section 35 rights might be adversely affected. Those are constitutionally protected rights.
And these decisions have to be public. We get to see the list and why things are on it.
Section 5.9 requires the orders changing the list and the reasons behind them to be published in the Canada Gazette. So transparency is built in there.
Okay, now let's get into the how. How does this achieve the accelerated process? Section 6 has this deeming provision. What does that do?
Right, this is a core mechanism. Section 6.1 says that for a national interest project listed in Schedule 1, any determination, finding, or opinion normally needed under a federal law before an authorization is given. Well, it's deemed to be made or formed in favor of letting the project proceed.
Whoa. So the preliminary steps required by law are just assumed to be met in favor of the project.
That's what deemed suggests here for their specific preliminary findings. But there are crucial caveats right after. Section 6.2 says this doesn't mean the project proponent gets off scot-free. They still have to take all the necessary steps to get the authorization.
Okay.
And Section 6.3 adds that an authorization isn't granted just because of this deeming. It facilitates but doesn't automatically grant the final permit itself. The proponent still needs to act.
Then Section 7 describes a duty to issue document. This sounds like the main streamlining tool.
It certainly seems central. Section 7.1 says the minister must issue a single document to the project proponent. And Section 7.3 states this one document is legally deemed to be each and every federal authorization specified within it.
So instead of getting, say, 5 different federal permits, the proponent gets one master document from the minister that counts as all 5.
That's how the text describes its function, yes. But
Yeah.
getting that document isn't automatic either. Section 7.2 lays out conditions. The minister needs to be satisfied. The proponent did their part, provided info, paid fees.
What else?
Crucially, the minister must consult the minister responsible for the original law about what conditions should go into this single document.
And Indigenous consultation again.
Yes, explicitly. Section 7.2c requires that Indigenous peoples whose Section 35 rights may be adversely affected by the project must be consulted before this single document is issued. It's a mandatory step.
And the conditions included in this master document, they act like conditions from the original permits.
Exactly. Section 7.5 says they're deemed imposed under the original laws. Section 7.6 adds they have to be conditions that could have been imposed under those original laws, keeping in mind that deeming provision from Section 6. And interestingly, Section 7.7 says this document isn't subject to the Statutory Instruments Act. That usually governs how regulations are made, so this suggests a more direct, perhaps less standardized process for this document.
But it has to be public, right?
Yes, Section 7.8 requires the document and any changes to it be made publicly available.
What if things change? Can they update this document? Section 8 seems to cover that.
It does. Section 8 allows the minister to amend conditions or even add new authorizations and conditions to the document later if needed.
With consultation again.
Yes, Section 8.3 mandates consultation before amendments. With the relevant minister for the original law, and again, with Indigenous peoples whose Section 35 rights may be adversely affected by the change, that consultation point is really emphasized.
Now, the bill then gets into specifics for certain types of projects. Offshore energy, nuclear, pipelines maybe?
Right. Sections 9 through 18 deal with specific regimes. For offshore projects under the Atlantic Accords, Sections 9 and 10 require consulting the Offshore Energy Regulator. For nuclear projects under the Nuclear Safety and Control Act, Sections 11 and 12 require consulting the Canadian Nuclear Safety Commission, the CNSC.
And for projects under the Canadian Energy Regulator, the CER.
Sections 15 and 16 require consulting the CER Commission, so consultation with the expert regulator is built in for these sectors.
But for nuclear and CER regulated projects, there's more than just consultation, isn't there? A harder stop.
A very significant one, yes. Sections 13 and 14 say the minister cannot issue or amend the document for nuclear projects unless the CNSC confirms it won't compromise health, safety, security, or international obligations. It's a CNSC check.
It's the same idea for CER projects.
Yes, Sections 17 and 18 say the minister cannot issue or amend the document for those projects unless the CER Commission confirms it won't compromise safety or security of people or facilities. So, for these specific areas, the expert regulator effectively holds a key piece of the approval power, according to this text. It limits the acceleration potential if safety concerns aren't met.
Got it. There's also a quick mention in Section 19 about the Impact Assessment Act, something about non-application of certain provisions.
Yeah, it's just a note in these excerpts. It signals some interaction, maybe an exemption relating to the federal impact assessment process, but we don't have the details of which provisions from this text alone.
Okay. And like Part 1, this Building Canada Act also requires a 5-year review.
Yes. Section 24 mandates the minister review this act's operation within 5 years and report back to Parliament.
Okay, so let's try to pull this all together, based just on these excerpts from Bill C-5.
Well, we've seen two main thrusts. Part 1, the Free Trade and Labor Mobility Act, tries to streamline the federal side of moving goods, services, and workers across provincial lines. It uses mechanisms like deeming provincial requirements meet comparable federal ones and mandating federal recognition of provincial work credentials, all subject to potential exceptions via regulations.
Right. And then Part 2, the Building Canada Act, sets up a framework to fast-track federal approvals for specific projects labeled national interest. Key tools there are deeming preliminary findings favorable and consolidating various federal authorizations into one ministerial document.
But importantly, that Part 2 process includes mandatory consultation steps, especially with Indigenous peoples regarding Section 35 rights, and hard checks involving safety regulators like the CNSC and CER for projects under their watch.
And the bill's stated goals, throughout the text we looked at, circle back to enhancing the Canadian economy, security, autonomy, facilitating projects.
while also stating intentions to protect the environment and respect Indigenous rights, primarily through those consultation mechanisms and specific safety checks we noted.
And just to reiterate for you listening in, this deep dive was based strictly on the excerpts provided from the Bill C-5 text itself. We're describing the mechanisms and purposes as written in the bill.
So, thinking about these mechanisms, particularly in Part 2, the deeming provision, the single document, the consultation duties, those specific safety checks, what questions does this text raise for you? How do you see the balance described here between speeding up projects and ensuring thorough oversight? And looking ahead, what parts of this bill, as laid out in the text, do you think might have the most significant impact on Canada's development or internal economic flows?